Beijing. Since Malaysia Airlines Flight 370 went missing, some lawyers have claimed they can get several millions of dollars in damages for each lost passenger by taking the cases to the United States. But past lawsuits show U.S. federal courts are more likely to throw such cases out if the crashes happened overseas. Major disasters draw lawyers looking to sign up clients for big lawsuits, and the missing Malaysian plane, which was carrying mostly Chinese passengers, has been no exception. Lawyers from various firms have descended on a Beijing hotel where relatives of the passengers have been staying, and have even traveled around China to visit them in their homes. The Chinese relatives have said their main focus remains on the search for the plane, so lawyers have had little luck so far in signing up clients here, despite dangling the potential of major damage awards. This is not the right point in time to discuss legal matters because nothing has been found yet and everybody has no idea what exactly happened to the plane, said Steve Wang, a representative of some of the Chinese relatives. Relatives can expect to get at least about $175,000 from Malaysia Airlines for each lost passenger under terms of the Montreal Convention, an international treaty governing air travel compensation. The relatives can also sue the carrier in Malaysia or their home countries for further damages. Chinese made up 2/3 of the 227 passengers aboard Flight 370. Which disappeared March 8 en route from Kuala Lumpur, Malaysia, to Beijing. Searchers looking in a stretch of the southern Indian Ocean have yet to find any debris from the plane. Malaysia Airlines said in an email that it was focused on helping the families of the passengers and 12 crew members, and that other matters will be dealt with appropriately. Some lawyers have argued that the families could still sue in America if they allege the plane's U.S. manufacturer, the Boeing Co., was somehow responsible for the disaster. But such lawsuits are likely to be rejected if they're filed in the United States because federal courts there have dismissed many similar foreign air crash cases, especially if most of the plaintiffs are not American. The courts have tossed out lawsuits against U.S. parts makers in connection with the 2009 crash of Air France Flight 447 in the Atlantic Ocean. They also dismissed lawsuits against Boeing in the 2008 Spanair flight that crashed on takeoff in Madrid and the 2005 Helios Airways flight that crashed near Athens, Greece, when a loss of cabin pressure caused the people on board to lose consciousness. The U.S. courts have ruled that it would be more convenient for the claims to be heard by a court in the country where the crash happened or where the investigation is taking place, making it easier to obtain witnesses and evidence. Courts with crowded dockets are likely to dismiss foreign plaintiffs where there are language problems, esoteric laws or missing witnesses, Joseph Sweeney, an emeritus professor of law at Fordham University in New York, wrote in an email. Sweeney said dismissal of foreign claimants based on such grounds has been almost customary since the U.S. Supreme Court's decision in 1981 to throw out lawsuits resulting from the crash of a plane in Scotland.